of the added respondents. But, as I speak, Pillar, I don't think that there's too much for me to add. There's just one or two very simple points, Pillar, which I may remind your Lordship, Pillar, because it's been
Who are you representing?
item number 50, can number 5, Saurav Acharya.
এটা বোধহয় অ্যাড হয়নি না?
Rahul Mondal.
আচ্ছা ঠিক আছে।
Lord, the first thing that your Lordship, Lord, marks is Rahul Mondal was unsuccessful. On that score itself, Lord, the writ petition should have gone. That's one aspect in the matter. So this not being Lord, a public interest litigation, his personal
এখানটা আমি দেখছি।
his personal affectation, Lord, is not there.
He is unsuccessful where?
In the he's not there, Lord, in the interview at all. He was not called for the interview, if I'm not mistaken.
Interview was later on. He filed.
Yes, Lord, he filed it earlier, so now, Lord, it becomes
No.
redundant. But anyways, Lord, that's one part of the matter. That's fine, Lord. Now, I shall address your Lordship only with respect to the 10 marks. Nothing beyond that. Now, my lord, this 10 marks, as my learned senior friend just now said, that was a subject matter, my lord, in a previous litigation. Now, this was, my lord, countenanced by them, saying, my lord, that the rules were not challenged there in that writ petition, because there's a line written in that
Is it
judgment.
Arunima Paul?
Yes, my lord. Now, in the Orunima Paul, my lord, this 10 marks and why this is fine was discussed. I shall place just two paragraphs, my lord, from that judgment. My lord, that might not be, it might not be, my lord, res judicata, but then, my lord, the findings are binding upon your lordship, that being of the division bench. My lord, kindly takes up Orunima Paul's judgment and takes up, my lord, paragraph 31st in that judgment. Your lordship has it, my lord. If not, I'll Orunima Paul's judgment. It should be there, my lord, even in my
Your application, is it there?
yes, my lord, in my application it's not there, my lord. But it's here.
I'm going on adding up papers.
Now, there are the
ওইটাতে হবে না, এইটা দেখি।
there's a compilation which has been given, my lord.
By the commission.
Judgment.
Eight, Shayab, eight. In this compilation, my lord, page 128. My lord, your lordship takes up the division bench itself, my lord, at 152. Takes up, my lord, paragraph 30. Internal page 19. I'm not going to trouble, my lord, the entire. Kindly comes down, lordship, kindly got that? Comes down, my lord, paragraph 30. Last line. According to the petitioner's distribution of marks, that is 10 for prior teaching experience, 10 for interview and 10 for lecture demonstration ought not to have been provided, which would grant the recruiting authority and the interview board unbridled power to allot marks indiscriminately. So this allocation of 10 marks was a subject matter in that writ petition before the single bench as well as the division bench. Then kindly comes down right at the, my lord, it be profitable, my lord, if your lordship sees paragraph 32, how, my lord, this was dealt with. And I'll show your lordship below 3 paragraphs, my lord, from this judgment, and then I'll take your lordship to the other judgment.
Yes.
Paragraph 32, my lord. The policy decision of the government is subjected to judicial scrutiny only in exceptional circumstances where it appears that the policy or some clauses in the policy is or are manifestly arbitrary, discriminatory, mala fide, unreasonable or unfair, or if it is found to be against any statute or constitution. If it is dehorsed the provisions of the act or legislation, and if the delegate has acted in excess or beyond its power of delegation, such policy can be declared to be ultra vires. Because this is taken to be, Milord, this allocation of 10 marks has been accepted to be, Milord, public policy. Intelligible differential. This is very important. I'll show a Supreme Court below thereafter. The recruitment rules 2025 per se is not under challenge. This is what your Lordship felt from your Lordship. Intelligible differentia for the purpose of selection of suitable candidates shall not be interfered with unless such criteria appears to be arbitrary. There is an intelligible differential between unsuccessful candidates and in-service candidates. When an expert body has taken a policy decision with regard to the eligibility criteria of candidates to be applied for appointment of assistant teachers for classes 9 to 10 and 11 to 12, and has elaborately laid down the guidelines, the court in judicial review should not substitute the said views with its own perceptions. Education plays an important role in shaping the society and country. We are waiting here for a moment. Beloved, the state is the employer. The state wants to employ or give employment to, Milord, a certain category of persons. Milord, what does it do? It, Milord, creates a balance. In my respectful submission, Milord, it is for the persons, the employee, to find out who is the best person, Milord, eligible for the job. Now, when does it become arbitrary? When, Milord, a certain criteria or a category is completely ousted, Milord, from the field. Today, Milord, if a balance is created, Milord, why I say there's a balance? Because if your Lordship sees, Milord, a lot of charts have been given to your Lordship to show, Milord, how the marks have been allotted and how, Milord, the marks are given, Milord, to the candidates. Now, if these 10 marks, does it, Milord, in any way throughout the freshers? No. But it creates a balance, Milord, where a person with some experience will have certain amount of, Milord, advantage, but vis-a-vis, Milord, the freshers. You can't say in every field, Milord, that a person who has experience will also be Milord, pitted against a person who is a fresher. The government might want somebody, Milord, with some sort of experience, Milord, because this is a specialized job. Teaching is a specialized job. It's not something, Milord, which is open for everybody and anybody. Milord, if a criteria comes in that somebody who knows how to, Milord, cook is given 5 marks, Milord, to become a teacher. That is, Milord, where, in my respectful submission, Milord, it becomes arbitrary, which has got no nexus, Milord, with the employment which is to be generated. Then, Milord, kindly comes down, right, Milord, to paragraph 34. The awarding of 10 marks is a weightage to be given, my Lord, kindly got it, Milord? Weightage to be given on the basis of experience, and is only expected that in a selection process of this nature and kind, and all the candidates are required to undergo the rigors of the selection process. In order to select the most suitable candidates, proportionate weightage based on the length of experience to the extent of 10 marks be given to such candidates is not arbitrary. So this is no longer, Milord, res integra. Giving this 10 marks for, Milord, the experience is no longer arbitrary. This is a finding which is final. So whether, Milord, this part of the rule is arbitrary or not, Milord, has already been decided, Milord, in the Orunanga Pal case. This is one part of the matter, Milord, which I wanted to remind your Lordship. The other part is, Milord, has it ever been done? These 10 marks being given, Milord, to experience? Has been done. Milord, your Lordship has seen Tej Prakash's matter, Milord. My senior friend showed your Lordship. It is also been done, Milord, in a more recent judgment. This is 2024, volume 8, SSC 124. Same thing. Volume 8 SCC 124. Let's see the first paragraph once. This batch of 47 appeals involves common questions of law. They arise from the judgments of Division Bench of the High Court of Judicature. The main appeal such and such arises out of judgment of Division Bench. The other matters arise out of the same batch as Maheshwar. Then, my lord, 3 is fine. Your lordship need not trouble my lord self. Kindly have a look at paragraph 13. Here, my lord, the 10 marks was given. General knowledge 40 marks, personality 35 marks, experience 25 marks. And a maximum of 10 marks be given according to 2 marks per year for a maximum of 5 years. In a lot of ways similar to what our rules in the 2025 rules. This was formulated, the questions were formulated. Your lordship will find that at page 133, 22.2. Is the award of bonus marks to the projected employed applicants discriminatory and ultra-virus the rules? Are the guidelines such and such sanctioning the award of bonus marks on a differential basis for applicants with project experience and other applicants invalid for any other reason? So basically, my lord, experience was given a certain amount of marks. Supreme Court takes it up, my lord. First of all, my lord, it takes up, my lord, if your lordship goes back a little bit, there was a submission which was made, which is recorded at paragraph 16. It just goes back a little bit, my lord. The learned counsel also contend that the advertisement of 31st of such and such did not sanction the grant of bonus marks, and the administrative guidelines dated such and such were not brought in public domain. It was argued that the rules of the game have been changed after the match has begun. This was the argument. It was contended that if the intention of the legislature was to create the set post only for para teachers working in project, the same would not have been offered to private and other teachers as well. This was the submission made. Then Milord kindly turns over to paragraph 24. This is the reasoning, Milord, of the Supreme Court, the ratio. See the first line. Fixing of minimum and maximum age requirement is a policy decision. In this case, the said decision, my lord, thereafter it's on the facts of that matter, my lord. Your lordship need not trouble my lord self. Kindly turns over, my lord, to paragraph 26. The challenge of the appellant is only to cause 5. We find that the provisions generally including V are not arbitrary or discriminatory insofar as clause 5 is concerned, as has been mentioned herein above. The historical background leading to the enactment of the rules itself provides a justification for granting relaxation to the person serving under the educational project if they fulfill the condition that they were within the age limit when they were initially engaged. As the counter affidavit of the state indicates that the projects were designed to deal with absentee teachers in the far-flung areas, which was causing a serious jeopardy to the education of the rural children, the para teachers, as they were called, worked under difficult circumstances. They had the advantage of interacting personally with the children of the far-flung areas. They only received an honorarium. The projects themselves played a large part in uplifting the elementary education program in the state. The para teachers motivated the children to come to school. It Prabandhak and things like that. Now, 28. No doubt, under the rules, opportunity to apply was also given to all those who possess the essential qualifications and who had teaching experience in any recognized educational institutions apart from the educational projects. This, however, does not mean that those who served in projects did not form a separate class. There was a valid classification based on intelligible differentia, which distinguished applicants with project experience and those who lacked project experience. This is what it is, Milord, with respect to our matter as well. This 10 marks is given to people, Milord, who have worked early. The government, Milord, in my respectful submission, wanted to create a balance between experience and youth. Can the youth not defeat experience? Yes, it can. Milord, by writing an exam which is of 60 marks, the youth has ample opportunity, Milord, to defeat, Milord, persons who have experience. Milord, if your lordship looks to, Milord, even if a private individual wants to, Milord, employ a lawyer, it's always, Milord, at times, if they can, the persons with experience are always given some sort of a weighting. And it's not their fault that they have, Milord, the experience. Lord, if this is what it is, then every time, the rule would have to be that there will be no weightage which is to be given, to experience at all. And everybody will have to have, that positive playing field or something like that. Milord, there's a very important concept called positive discrimination. Milord, today, if the government feels that these persons having this sort of experience has some sort of advantage in dispensing, Milord, education, the government has a right to, Milord, make its own policy. If it's arbitrary, Milord, if it takes away everything from someone, Milord, I quickly, Milord, hasten to remind your lordship about the Venugopal's case. Milord, in Venugopal's case, what happened? Milord, that's the AIMS director. What happened, Milord, was the entire law, Milord, was framed so that Venugopal could never become the AIMS director. The Supreme Court said that you can't make a law which takes away the right of that one individual. Milord, if you take away a right completely, Milord, that's arbitrary. Here, Milord, an ample weightage is given to people who have some experience. Now, this is in consonance, Milord, if your lordship sees 28 and then, Milord, 30 is the paragraph. I'll just read it for your lordship and then take your lordship to the other part. Milord, if your lordship comes down to 31, insofar as the award of bonus marks is concerned, a careful perusal of the guidelines indicates that it was issued before the advertisement and all that it provided was out of the allocated 25 of the experience. Ordinarily, 2 marks were to be given for every year with a cap of 10 marks. However, if the experience is for the employee receiving honorarium under the projects run by the state government, then he was to be given 5 marks for each academic session. Even if a part of the experience was in a project to that extent, extra marks were provided to all the applicants. In the application form, there was a specific column, namely column 14, which asked about details of the experience. The form also asked for the name of the employer and the address of the institution employed. Thereafter, there was another column. Well, it's the same thing that comes in. Sees paragraph 34. In Srinivas, a notification was issued inviting applications for the post of junior lab technician. Eligibility and requirements were prescribed. At the time of selection, the selection committee decided that out of 15% marks for interview, 10% of the marks would be set apart for the length of work experience and or additional training in teaching hospitals of the medical college, with special preference for those who had worked in teaching hospitals of government or autonomous medical colleges, and the remaining 5% were to be assigned to the personality of the candidates based on viva voce. In the minutes, it was set out as under. Then the minutes are recorded. So, Milord, this is what has been done all throughout. It's not, Milord, for the first time that experience has been given some sort of weightage. And Supreme Court has held, Milord, that this can be done, and this is a part of, Milord, positive discrimination. Milord, I hasten to add here, there's a very big pointer, Milord, in the Supreme Court judgment in Boishaki, which was the first judgment, Milord, which was the untainted persons, Milord, there will be no break in service, my lord, with respect to them. Kindly looks to that paragraph once. This is a pointer why, my lord, weightage should definitely be given, my lord, to these gentlemen. Kindly have a look at, my lord, page paragraph 47 of that judgment, of the Supreme Court judgment. Compilation আছে পেড করে নেন পেজটা বলবেন my lord, it's the first page and sees, my lord, paragraph 47.
Some of the appointed
Yes, yes, ma'am. Some of the appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of the state government or with autonomous bodies, etc. In such cases, although their appointments are cancelled, these candidates will have the right to apply to their previous departments or autonomous bodies to continue in service with those entities. These applications must be processed by the respective government departments or bodies within 3 months, and the candidates will be allowed to resume their positions if they want to go back to where they were. Further, the period between the termination of the previous appointment and the rejoining will not be considered as a break-in service and their seniority. Now, my lord, why I'm saying this break-in service is important is because, my lord, that they were working is, my lord, accepted, my lord, by the Supreme Court and given due weightage. That they were not in, my lord, we are victims of circumstances. What the Supreme Court did, my lord, was that they created a class out of a class. We were given appointments, but we were not people who were in any way related, my lord, to the misdemeanors. So we were given certain, my lord, advantages, and we are entitled to take advantage of, my lord, that of the advantages which is given, my lord, by the Supreme Court. So if there is no break-in service, and if I have gained experience, in my respectful submission, my lord, if the government has a policy of giving me, my lord, certain amount of weightage, I'm entitled to have that. It doesn't in any manner give the others any less importance, my lord, if they can come out, my lord, with in their own, my lord, merits. These are my respectful submissions, my lord. If it is arbitrary one, no, my lord, that's grateful to you, Lordship.